Now, there was drama at the Supreme Court on Thursday, that's today, as renowned lawyer Tachu Chikata refused to argue the NDC's review of the Voters Register case. According to him, he had just received documents filed by the Electoral Commission and was therefore unable to argue the case. The Supreme Court had ruled that the EC can compile a new register as it excluded the use of birth certificate and existing voter's card as proof of identification. The NDC had wanted this decision set aside through the review application. The court, however, disagreed. Court correspondent Joseph Akable with more.
The initial case was heard by Chief Justice Kwesi Eni-Nieboa and Justices Jones Doche, Paul Bafuboni, Sule Gbadegbe, Samuel Mafusau, Nene Amegacha, and Professor Ashikote. But the NDC filed for a review with Justices Yawapil and Mariama Owusu joining the panel. The NDC also filed a request for the case to be heard earlier than usual. The court granted this request, but Mr. Chikata said he was unable to argue the case. He said his junior Dr. Dominic Ayene had written to the Chief Justice suggesting that the case be heard during the vacation. He also wanted time to file additional documents. The court took the view that the request to file additional documents was not supported by law. The Apex Court directed Mr. Chikata to move his review application, but he refused, saying he needed more time. Deputy Attorney General Godfrey Yeboah-Damit therefore urged the court to dismiss the case. The court granted the request, saying the review application was without merit. Member of the NDC's legal team, Abraham Amaleba, says the court's decision flies in the face of justice.
Also, affidavit was served on us very late, and so there was the need for the counsel, Chikata, to apprise himself. He wasn't going to be able to move the motion to assist the court to arrive at an effective decision. And so Chikata was of the view that just grant me an adjournment which will enable me read through the processes that were filed and served on me whilst I'm on my feet. The Supreme Court did not take none of that.
The Deputy AG says you are running away from your own application.
The Deputy AG knows very well that if a process is filed on you while you are in court and you have not been able to look through that process, you request for time. You ask the court to give you a short adjournment to be able to look at the opposition's affidavit. The Deputy AG was on the frolic of his own. Indeed, he only played to the gallery. He knows that in the practice, you do not go ahead to move a motion when an affidavit has been served on you and there are some substantive issues that you must address in that affidavit in opposition. I think that the Deputy Attorney General was played to the gallery on this occasion.
This brings an end to the NDC's quest to have the voters' card used as part of the ongoing registration exercise.